Ma'am, you're Crystal Julian. And so Ms. Julian was previously in court and entered a plea of guilty to burglary of a building, which is a state jail felony that was enhanced. And the agreement was for a 10-year term in prison, probated for 10 years with restitution to be determined. There were some issues. Looks like I reset.
It was positive last time.
Right. And so I raised the bond, reset it for a couple of weeks, got a substance abuse assessment done in the meantime. Did everybody get a copy of that substance abuse assessment?
Did you?
Okay. Did you not?
I didn't, but I defer to the court on that.
Okay. Yeah.
I'm saying you didn't, I just,
It's
sometimes they slip through. Sorry.
That's okay. So y'all have all been able to review the pre-sentence report, correct?
Yes.
Is there any reason not to go forward with sentencing at this time?
No, offense change.
Judge, obviously the state is aware of the court's concern about her criminal history, just so that you know, the co-defendant was sentenced to significant prison time in this case. I believe he was actually the one more culpable based on the facts. I've also reached out to the managers of the storage facilities in an attempt to gather a restitution amount. Obviously, her offer was made with the enhancement in an attempt to reclaim or regain that restitution. They were unable to provide me with that. I also reached out to the detective with respect to their attempts to contact all the individual owners, and I didn't receive a word back from that. It's my thought that probably they recouped those losses off of their personal property insurance.
Okay. Okay. So do you have any input as to the recommendation under that substance abuse assessment is for either SafeP or ISF followed by JCDI? Any input, Mr. Lewis or Ms. Malfino?
What Judge, in talking with my client, she's more than willing to comply with whatever help that the community supervision department can give to her, especially when dealing with the mental health issues, which I think that's what kind of leads to a lot of the substance use problems that she's had. And she's straightforward and honest with them during the evaluation. So, Judge, I mean, whatever the court deems appropriate, she's more than willing to comply.
Let me just. I guess I'm trying to decide if the substance abuse evaluation is very confusing because it says he and his the whole time instead of her. So that we're talking about the correct person, I believe. It's just,
Right.
yeah. No. I don't know that what I'm looking for is to see if it states in here if special needs SafeP would be appropriate. I don't know based on the diagnosis of depression and anxiety if that is enough for that. With how does that determine? Do you know?
She would already have to be diagnosed in order to do the special.
I mean, there's a diagnosis, it looks like. Well, I say that. Have you actually been to,
No,
you have not been actually diagnosed. That's just how you feel.
Yes, ma'am.
Okay.
I mean, I was diagnosed when I was a kid, but.
Right, but you haven't anything recently.
Yes.
Okay.
No.
So, all right. Anything else then?
No.
No.
All right, Miss Julian, what I'm going to do, at this time, I'm going to find that you previously entered your plea of guilty and true freely and voluntarily.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time, find you guilty of burglary of a building.
Yes, ma'am.
And find those prior convictions true.
Yes, ma'am.
Sentence you in accordance with your agreement to a term of 10 years in prison, but that's going to be probated. You'll be on probation for 10 years. Because there was no restitution amount that was turned in, I am going to order that you pay a fine of $500
Yes, ma'am.
and that you follow all of the rules and conditions of probation.
Yes, ma'am.
One of those is going to be that you enter and successfully complete the substance abuse track of the ISF program.
Yes, ma'am.
And then when you're released from there, you will go through the outpatient JCDI program as your aftercare. I'm also going to ask probation when you are released to do a mental health evaluation. And if there's anything that you need, if you need to be on a specialized caseload at that point, they will put you on that to help you with any other issues that you're having. And so if you do everything that you're supposed to when you're on this probation, this is a great opportunity because for all practical purposes, your case here in court is over.
Right.
The other side of that, though, is if you violate any condition of probation
Yes, ma'am.
and you test positive, you don't show up
Right.
for whatever it is, then you
No
will be
exception.
back in here and you'll be looking at that 10-year sentence that you've already agreed to.
Yes, ma'am.
All right. I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you waived your right to appeal.
Yes, ma'am.
I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Oh, I don't think they did it.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. I've got to read this to you.
Okay.
Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lewis. And I will sign a dismissal as soon as it comes through as part of that agreement and cause number 25, DCCR 1394.
Yes, ma'am.
All right. Good luck to you, ma'am. You can go back with the bailiff.
We got to play with him.
Let's see, Miss Malfino on Donald Cogdale. All right, sir. Again, you're Donald Cogdale.
Yes, ma'am.
Can you hear me okay like this?
Yes.
And will your client waive the formal reading of the indictment?
He will.
Mr. Cogdale, I have to go through that indictment again, even though I already did. In cause number 26, DCCR 0005, you are charged with the state jail felony offense of evading arrest or detention with previous convictions from June 25th of 2025. The indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. It further alleges that you were convicted of burglary of a habitation, first-degree felony, December 22nd of 1993. After that was final, you were convicted of burglary of a habitation, a first-degree felony, November 7th of 1994. That's enough for a second, if that's okay.
Yes, Judge.
How do you plead to that charge?
How
Guil-
you plead? Guilty?
Guilty.
And are those prior convictions true?
Yes.
Are you pleading guilty and true freely and voluntarily?
Yes.
And did you plead guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Stuff you signed, I explained to you. Yes.
Do you understand those documents that you signed with Mr. Parker?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal? So as long as, and the agreement is for a cap of 8 years in prison, which means you're leaving your punishment up to me. And as long as I give you 8 years or less, you cannot change your mind and appeal later. Do you understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
All right. I have to ask everyone that. State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Cogdale is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea.
At this stage, the court wasn't debating beliefs. It focused on evidence, prior convictions, and whether probation conditions were met. Substance abuse, failure to complete programs, and new offenses all weigh heavily on sentencing decisions.
Find sufficient evidence to find you guilty, but I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker and he will present it to me on your behalf when we come back. All right? I'll see you back at sentencing. You can go back with the bailiff.
Thank you.
It was a TRN and now there's a new thing that's popping up about fees and yes, I love that. Good morning. Are you Brianne Deshawn Williams?
Yes, ma'am. Good morning.
And this is 18-30512. Ms. Williams has a motion to revoke her probation. What is the announcement?
Your Honor, the district attorney's office is showing she has a case received. It's a 2024 offense date, but it's been received. And it appears she had a previous hearing back in 2024, which I think that offense may have been addressed, but it's just now getting to the DA's office to possibly be indicted.
Okay.
Based on the dates, I would agree with Ms. Holmes that the 11/19/24 admin hearing addressed that.
Okay.
But there have been delays with the lab, so I'm not surprised that it's just coming around, but it is received and the state would like to have an opportunity to review that once indicted.
All right. So we'll just do one normal reset. That way, obviously, if there's another case, you can get it all taken care of at the same time. Ms. Holmes will get all of that information from Ms. French and she'll be out there to visit with you, go over what your options are. And then we'll see where we are at that next court date. Okay. All right. Okay. Go back to the bailiff.
Thank you.
Good morning. Are you Dan Witet?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor. Or it's a.
I'm sorry, the motion.
Yeah.
Yes, hold on. Let me get that pulled up. Let me get it pulled up real quick. Okay, Mr. Whitson, in cause number 24, DCCR 0198, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for the third-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 3-year deferred probation that's been extended for 2 years. Is that correct? The motion alleges you violated your probation. Count 1 alleges that you failed to successfully complete the safety program and the aftercare, and that you were removed from it on December 18th of 2025. And is that true or not true?
It's true.
Count 2 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
And then count 3 alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitted is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty, and at this time, find you guilty of the third-degree felony offense of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Yes, ma'am.
So, Mr. Lamel, I just wanted to visit with you, and so we can hopefully get your case moving forward. I know Mr. Adams has had some issues and has been unable to come to court. He filed a motion to withdraw as your attorney. Do you have any objection to that?
I don't know what you're talking about.
He wants to withdraw and not be your attorney.
Yeah.
Are you okay with that?
Yes, ma'am.
Okay.
They wasn't coming.
Right. And so here's what we can do. I can, because you're in custody, I can appoint an attorney today who can start working on your case. Do you want me to do that? Or do you think that you or your family have money to try to hire someone else?
No, ma'am. You can give me a.
Okay. I will appoint someone today. I will let that attorney know that you've been coming and we've been having some issues and you're just sitting and waiting. And so hopefully they'll get up to speed real quick and we can see what we can get done with your case. Okay.
Thank you so much.
No problem, sir. You can go back with the bailiff. So if you want to print out that order, I'll sign it.
On the case, I did check with North County. They said the case has not been filed. They said it's in review.
Okay. All right, sir. Are you Mark Phillips?
Yes, ma'am.
Mr. Phillips, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. And will your client waive the formal reading of the motion?
Yes, Your Honor.
Mr. Phillips, in clause number 21-36585, I have a motion to revoke your community supervision. Shows that you were placed on probation September 13th of 2021 for the third-degree felony offense of unlawful possession of a firearm by a felon. And that was a 10-year term in prison that was probated for 5 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the new offense of assault family violence in Orange County on October 3rd of 2025. And is that true or not true? Count 2 alleges that you provided a urine sample August 13th, September 10th, and October 13th of 2025 that tested positive for marijuana. Is that true or not true?
True.
Count 3 alleges that you admitted to your Orange County probation officer that you used marijuana on or about August 27th of 2025. Is that true or not true?
True.
Count 4 alleges that you provided a urine sample November 6th of 2025 that tested positive for marijuana. And is that true or not true?
True.
Count 5 alleges that you admitted to the use of alcohol on August 27th of 2025 to your probation officer. Is that true or not true?
True.
And then count 6 alleges that you failed to prove the attendance of AANA meetings as directed by the substance abuse evaluation. Is that true or not true? So did you enter your pleas of true to counts 2, 3, 4, 5, and 6 freely and voluntarily? And because those counts are actually true. All right, then I'm going to find that you entered your pleas of true to counts 2 through 6 freely and voluntarily, find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing, get the probation department to do an updated report that'll give me more information about what's been going on, maybe get some more information about that count 1, the assault case, if the state intends to bring any evidence with regard to that. Well, I would think an 11 o'clock hearing would be enough.
Should be true.
Okay, so we'll set it at 11 o'clock for a hearing on sentencing. All right, go back with the bailiff.
Again.
Oh, sir, this is Mr. Coleman's Kaylin Thornton. Good morning, sir. Are you Kaylin Thornton? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
The state's elected to proceed on the lesser included. Instead of the aggravated promotion of prostitution, the state's proceeding on a promotion of prostitution under 4303 of the penal code.
43.
03 of the penal code. It makes it a third degree as opposed to the first degree that the aggravated promotion of prostitution is.
Thank you. And will he waive the formal reading of the indictment as?
Yes, Your Honor.
All right, so Mr. Thornton, in cause number 26 DCCR 0220, the state's elected to proceed on the lesser included offense of a third-degree felony, promotion of prostitution from November 15th of 2025.
Defendants were sentenced according to law. Some received probation with conditions, others were reset for further evaluation. The takeaway: compliance matters, and ignoring court mandates can result in serious penalties.